Good afternoon. Welcome to the Joint Veteran Endorsement Interviews for Judicial Candidates. On the onset, we would like to formally recognize and thank you, our sponsoring organizations, for making today's event possible. Veterans International Politics, Nevada Veterans Association, the Armed Forces Chamber. We also like to extend our sincere appreciation to our additional sponsors and community partners who support and ensures the professional, fair, and transparent endorsement process. Our sponsors are noted: Judge Jacob Reynolds, Department 29, Judge Mary Perry, Family Division P. Just a side note, the Department E, his interviews are moved to March 7th. We're honored to have you here, Judge Maxey.
Thank you. Thank you for having me.
First off, where it's going to go is the panel is going to introduce themselves and the organizations. Then you're going to have your chance. You're going to introduce yourself and give the reason why you're running for the position you're running for. I don't have to go over the rest because there's nobody here. So if that be the case, after that, you would be given a barrage. And you'll be given questions and you'll have 1 minute and 30 seconds to answer.
Okay.
Okay. So we'll start.
Sue Christensen, Nevada Veterans Association.
Leslie Caliano, Veterans in Politics International.
The moderator, J.P. Edwards from Armed Forces Chamber.
Gary Jacobs from Armed Forces Chamber.
Cindy Lake, Veterans in Politics.
Hello, everybody. Happy Saturday. My name is Kerri Maxey. I am the current sitting judge on Family Court, Department N. The reason why I am running for re-election is because I love my job. It's difficult, it's demanding, it's challenging, but I really feel like I can give back to my community and I'm helping these families in crisis. Because if you are a family going through the court system, especially family division, you are a family in crisis. And that is my way to help them protect the child's best interests and give back to my community.
So how do you handle cases where allegations are later unsubstantiated? Because we know in family law, there's a lot of mudslinging back and forth. When you find out it's not true, how do you handle it?
So unsubstantiated with CPS, unsubstantiated with anything. Well, that affects the credibility of the person that's in front of you. So if that person comes in front of you and makes allegations of domestic violence, and who knows, maybe the alleged perpetrator went to trial and won. So right there, that shows that the domestic violence didn't happen. I've also had cases where there's CPS allegations. I get the CPS records. I read them myself. And a lot of times, the allegations, you can tell, are just made as a weapon for divorce cases. It's sad that litigants believe they can win a divorce by using domestic violence allegations, allegations of abuse and neglect. But I have to remind the litigants that are in front of me, when you're going through a divorce, there is no winner.
When faced with social or cultural issues not clearly addressed in statutes, what guides your decision making?
You have to have respect for cultural issues. Actually, I don't know of any cultural issue that is prescribed or dictated in a statute or case law. However, every family is different. Every family has their own culture, their own family. And if there is a cultural issue, you respect it and you make sure it's protected. You can't use that as a weapon either. My culture is different from everybody else's culture, and I don't use my culture on the bench. My culture isn't going to change what you do differently, but what your culture is has to be respected. So I respect it and make sure it's protected and not used against a person as a weapon.
Gary Jacobs, Armed Forces Chamber. What are the statutory factors a judge must consider under NRS 125C in determining the best interest of a child?
Oh, there's 12 factors. There's a lot of, okay. So I hope I can remember all of them because there is a lot of them. The first factor is the child's wishes. If that child is of sufficient age and capacity to make a legal decision on their custody status. The second factor is whether or not there's ever been a nomination of a guardian. A year and some odd months on the bench, I've never run into that factor. I don't even know why we have that factor. Okay, so there's two. We have the ability of the parents to keep the association with the other parent. So if one parent has physical custody of the child, that parent has to have the ability and mentality and likelihood to continue contact with the non-custodial parent. You also have to have the mental health and the physical health of the parents, because sometimes parents has issues and they're not able to care for the child. You also have to look at the factors of the child's development, emotional and physical needs. Sometimes you have a kid that has special needs and one parent has the skills to take care of the child's needs, not every parent. You also have to look at the ability of the parents' cooperation. Can they cooperate with each other? Can they co-parent with each other? Which is ideal if you can. You have to look at their level of conflict. Yeah, and I only got through 7. And there's more. Sorry. Yes.
Cindy Lake, Veterans in Politics. We can continue if you'd like to go on to all 12, or I can ask you another question.
It's up to you. I thought there was no follow-up questions.
Okay. Okay, let's append to that and say, would you be able to use your intuition as a judge in really what is the best interest of the child, despite what it says on paper and despite what you have in the record? As a woman judge, is there any time when your intuition kicks in and you say something's not right here? And I'm going to also mention psychotropic medication. Add that into that because there's so many children on Ritalin, ADHD medication, and acting out, and so are many parents. So how do we know, really, without blurring the lines of 1 through 12, what is the best interest of the child? It's a multi-pronged question. And how much time can you put into really knowing what the best interest of the child is? And if the parents are in conflict about treatment, et cetera. So is that a lot?
That is a lot. And I'm going to do my best.
You can choose. Okay, thank you.
I'm going to start out with a little background on myself. Before I took the bench, I dedicated my practice to representing children. I represented kids who were arrested, abused, neglected, abandoned, and whose parents were deceased. So I know the red flags of when a parent says, oh, well, this is going on with my child. But then I sit and I talk to the child and I realize it's not really what's going on. There's something else. I also bring the child into my courtroom and talk to the child themselves. It's a controversial thing for judges to do. They always want another like FMC to interview the kids. But I bring them into my courtroom. I introduce myself. I don't wear my robe. I wear jeans, t-shirt, sweatshirt, make them comfortable. I let them choose where they want to sit in my courtroom. And a lot of times they want to sit on the bench. And I let them and I ask them questions. And you can get the truth of really what's going on in the family through the child. So that is usually what I concentrate is on the child's voice.
May I append and ask at what age is a 5-year-old too young for you to bring into the courtroom? Or?
I've represented kids from birth to age 18. So I can tell you I have met some 5-year-olds that have the strongest opinions, and they will tell you what's going on. However, I've met a 16-year-old that, well, the 5-year-old had a better opinion than the 16-year-old. So each child is different.
Sue Christensen, Nevada Veterans Association. I understand that most judges want to do 50-50. And ideally, that's what is great for the child if it works. And I know judges a lot of times automatically order that. At what time do you automatically always order 50-50, or do you read the stuff and make a decision there that maybe it's better for this child to be with parent A or parent B versus just the straight 50-50 right out of the gate?
You have to take each case individually. A lot of the times I will start with, where's the custody schedule we have right now? You know, if the child has been mostly with one parent through this divorce, why am I going to upset the boat just now? Let's keep the status quo. We'll set it for a trial. And then each person has their day in court to present the evidence to show me how they think custody has to be. But a lot of the times, let's just keep it status quo. Because it's also, I have to think about the mentality of that child. And if I can't just throw a child in with a parent where that child hasn't been with the parent, doesn't know that parent, that is detrimental emotionally and mentally to that child. But each case has to be taken separately. There can't be just a blanket decision.
Veterans in politics. My question is, how would you approach cases where there's a serious conflict between parental rights and a child's asserted identity or medical wishes, and are parental rights a priority for you?
Parental rights are a priority, but so are a child's rights too. I think that question is something that would, again, you'd have to take it individually and see exactly what are these medical issues. I can give you, when I was at Legal Aid Center of Southern Nevada, you have to understand I advocated for kids. I was representing a child who was Jehovah's Witness. And he was in the hospital, he had leukemia, and if he didn't have a blood transfusion, he was going to die. That child did not want that blood transfusion. I talked to that child, did not want it. And I had to make that argument in the courtroom. So you have to listen to the parents, you have to listen to the kids, and you have to have a balancing. Do I know the answer? No, that's hard. That's one of the most difficult decisions that I will ever have to make. But I would take my time. I'd make sure everybody has their day in the courtroom and their voice is heard, and I listen to it. And I'll probably go home and cry no matter what.
Gary Jacobs, Armed Forces Chamber. I was just looking up some statistics, and it was saying how 80% of custody goes to the mother and the 20% goes to the father. And I was just kind of wondering why.
I don't know. That is a good question. I don't know, because each parent has a right to have custody over this child. I'm a child of divorced parents. My mom got custody of me. And because of that, my dad, he didn't try to visit me. He even quit his job so he didn't have to pay child support. And I felt abandoned. And I wished that there was a judge that would have forced that father-daughter relationship. My dad passed away when I was 17. I never got that relationship with him, and I regret it. And sometimes growing up, I always wish there would have been somebody that would have just like stepped up and said, hey, have that relationship.
Right.
Yeah.
That was one of the questions I was going to ask you about the boy that the Jehovah's Witness boy.
Oh, yes.
But so what would you do then as a judge if both parents disagreed on that treatment. So you allowed you would allow the 10-year-old, or how would you go about
So there's
ruling in
case
that?
law. There's case law on that.
Okay.
And the case law actually protects the health of the child. And that's the best interest of the child. So you can appoint a guardian over the child, a guardian that just does medical decisions. In the case that I had, the parents hadn't decided on a guardian to be appointed. So they kind of found a way around their religious beliefs to save their child without being ostracized by their beliefs. But as a judge, there's case law on that. You decide on saving that child's life. Mm-hmm.
Sue Christensen, Nevada Veterans Association. I notice in court a lot judges will order communication between like My Family Wizard or an app that the judge has access to. How often do you look at that app? Because those apps are pretty telling on what's going on and which parent's being most difficult.
Well, so I just took the bench, all right? Okay, I've only been on the bench a year and a couple of months. I don't know how to have access to those apps. Nobody has taught me how to give me access to those apps. I would love to have access to those apps. They are, because in my trials, the parents will print out those text messages, and I will sit and read those text messages. And it's very telling, and it usually shows that both parents don't have clean hands. Nobody's coming to this courtroom with clean hands. Both of those parents are disparaging each other. Both of those parents are using that child as a weapon. But the app is good because you can't delete the text messages. And I tell the parents, this is either going to be your best friend or it's not going to. It's going to hurt you. But I wish I knew how to access those apps. I'm sorry.
Again, Leslie Taliano, Veterans in Politics. My question for you is, I'm going to lighten it up again. What clubs or organizations outside of your career are you involved in?
I used to be a choreographer. I used to choreograph for community theater, Roselle C-Strand Performing Arts Program. All of our proceeds went to Nevada Helping Hands, which is, we provided services for indigent elderly. That went away because Summerlin Library increased their rental fees for their theater. And because of that, we couldn't afford to rent the library and put on community theater anymore. But I still talk with all my friends. My co-choreographer, I talk with her all the time, so I do that. You're welcome.
Gary Jacobs, Armed Forces Chamber. Tell us about a legal position you once strongly held that changed after, and what caused the shift.
Once strongly held, that changed after. You mean like a legal position that I held, yes, and then after the hearing, or
of a study or experience, and what changed after?
And what changed after? On the bench or as an attorney? I just want to make sure. It does either way. On the bench, I don't have legal positions. You can't have legal positions. You have to apply the law, you have to apply it unbiasedly, and you have to apply it to the facts. When I was an attorney, I just believed in the Constitution. I fought for the Constitution, and I don't think I've had anything that ever changed my belief in the Constitution. I was a champion for the Constitution. I protected people's constitutional rights, or basically kids. And I don't think there's anything that can change my belief on the Constitution.
Excellent. Okay, Cindy Lake, Veterans in Politics. The N-word is thrown around a lot. And it's not that N-word. It's the word narcissist is being thrown around a lot.
Okay.
So I would like to know, when that word is thrown around in your courtroom, do you look further into that? Do you dismiss it? Have you done any research on that word and all that goes along with it? And have you ever done a quiz yourself to determine whether you are or not?
Well, I highly doubt I am. I'm too authentic and humble and kind. There's just no way. However, I've never had that word thrown around in my courtroom. No, it's usually this person is lying. This person is lying. This person is controlling. But never that word. What research have you found? I mean, I'd love to know. Please educate me.
I mean, there's a lot out there, but there's criteria,
Mhm.
similar criteria to
Like the DSM?
Yes, it's in the
Okay.
DSM, which I'm not a firm, strong believer in either, because those are just symptoms. There's no biological test for that or mental illness, really.
Mhm.
So, but, controlling, abusive, but only to one person, the, opposing party usually. So I'm kind of surprised actually that you haven't heard it, but
That word, no, it's never been used
and
in
if
the courtroom.
okay. So that was my question, and my question is: do you, when those terms are thrown around at each other, are you looking at the person accusing and saying, well, their hands aren't clean either, because usually both are not, but to what extent? Okay.
I have come to realize that there's 3 sides to every story. So there's.
I'm gonna give you 20 seconds.
Okay. There's the plaintiff side, the defendant side, and then the truth. So if I really believe, I have ordered somebody to go through a psychiatric evaluation. If I truly believe there's an issue and I need to get at the root of what's going on, I have ordered that. Mm-hmm.
Sue Christensen, Nevada Veterans Association. When parents divorce, really, the parents forget that there's a child involved and they become a pawn most of the time. How often do you recommend counseling for the child so this child doesn't have lifelong issues with this?
When the case and when the situation deals with it, absolutely. Absolutely. If I see that there's red flags, counseling for sure. I order family counseling as well a lot. I think there's a lot of times where the parents need to learn how to talk to each other. So I'm a big proponent of counseling. I order it.
Leslie Pelliano. Gotcha. Can you describe your judicial philosophy and how it will guide your decisions in complex family law cases?
My judicial philosophy, first of all, is temperament. One of the best ways to bring down high emotions is to show low emotions. So temperament is the first one. My second one would have to be respect. I make sure that all parties respect each other in my courtroom. One of my biggest pet peeves is talking on top of each other, interrupting. And I remind them, we're going to do what we've all learned in elementary school, take turns. And then my third is kindness. I lead with kindness. And it's really funny how contagious kindness can be.
Gary Jacobs, Armed Forces Chamber. If you discover post-election that a campaign volunteer made a statement inconsistent with judicial ethics, what steps would you take?
That a campaign volunteer?
Mhm.
I don't have any campaign volunteers. Please, if you want to volunteer, 725-312-8120, huh? Please, if you want to
Let me ask
volunteer.
one more.
Okay.
How would you handle a situation where a major campaign donor appears before you in court?
Oh, you have to divulge. You have to tell everybody. You can't just not say that this person, you can't keep it quiet. I mean, that would be against your judicial canons. You have to be transparent. And that's one of the things. Hey, just want everybody to know the defendant's counsel has contributed to me Just want to let you know. Doesn't matter that this person contributed to me because I'm going to apply the law as it is, and it's not going to sway my opinion. However, if you feel uncomfortable and you want me to recuse, I can still be unbiased, but I want that perception of unbiasedness. And if you feel I won't have that, then I will recuse myself.
Cindy Lake, Veterans in Politics. How much does your political affiliation play into your judging abilities?
0.
Okay.
Absolutely
Thank you.
0%. Your politics, your opinions should not be on the bench at all. And you can always tell when a judge politics, when a judge's opinions are on the bench, because that judge starts doing what I call legal gymnastics to get to the conclusion that they want. You shouldn't have to do legal gymnastics. It's right there. You just apply the law and you apply it unbiasedly to the facts. And that's what a judge is supposed to do.
Sue Christensen, Nevada Veterans Association. How do you handle when one parent continually violates your court orders?
Well, that's contempt. That's contempt. So it depends on the contempt, but contempt you can fine them up to $500, or you can give them jail time up to 25 days. A lot of times, I have given them jail time and suspended it and gave them the opportunity to purge their contempt. And just that threat has been enough for parents to start following my court orders.
Leslie Kelliano, Veterans in Politics. How would you approach cases involving allegations of domestic violence to ensure both safety and due process?
Very carefully, very slowly, and very seriously. You have to make sure everybody's voice is heard. You have to make sure you have a courtroom where people feel safe to be able to. Both sides. It's not just one side that has to feel safe. It's both sides that have to feel safe. Both sides that feel they can present their case, present their evidence, and I would make the decision. But it's nothing that you want to shoot from the hip on. I think it's something that you have to listen and apply the facts very carefully and be serious about it. Because if you get it wrong, somebody could die. Or if you get it wrong, somebody could lose their children. So it's the extreme on both ends. So you have to be very careful on it. Mm-hmm.
Gary Jacobs, Armed Forces Chamber. Describe your approach to maintaining decorum when attorneys engage in repeated speaking objections or grandstanding.
Well, first of all, I let them know. They say objection and they start arguing this big long argument. Counsel, what is your objection? What rule of evidence are you objecting on? After a while, I'll just, not unless you follow the rules of evidence, you're not going to be able to object. You got to follow the rules. I've had this happen a couple of times, and I make bracelets that say "Be kind," and I have actually brought the attorneys up to my bench, and I gave them "Be kind" bracelets, and it actually lowered the temperature, lowered the animosity. They're apologizing to me, they're apologizing to each other, and then they go back and they act like attorneys. And they do a good job. Because you have to warn them, you continue to act like this, you're doing a disservice to your client. And I could stop it, continue the trial, make you all come back, and that's going to be a waste of everybody's time. So, you're welcome.
I'm going to give you an easy one. Cindy Lake, Veterans in Politics. The Tonopah calculator, are you familiar with that?
No, what is it?
You're not? Okay. It's apparently a guideline that is loosely used by some attorneys or judges and was a group of attorneys had gotten together in Tonopah, apparently, and all got drunk and came up with this guideline.
Drunk mathematics?
But,
Okay.
okay, so what are your thoughts on alimony in general? And how would you determine whether a party were to get alimony or not, being that there is no set law?
There is no
In this-
calculation for, there's
There's no
I didn't mean to
calculation.
interrupt
No,
you.
that's
I
okay. Go ahead,
apologize.
Judge.
There is no calculation on alimony. There's just like kind of like a rule of thumb that it's the half of what the marriage was. So if it's 10-year marriage, alimony is 5 years. There's actual factors that you have to go through under NRS to determine alimony. And if you don't go through those factors, it's abuse of discretion. So you have to use those factors. You also have to look at the need for alimony and the ability to pay. You can't just say, oh, this is what this person is asking for and this is what they're going to give. I also like to employ what I call rehabilitation alimony, where the alimony gets tiered down, because a lot of times when a person going through divorce gets alimony, they are so dependent on that alimony, they don't do anything to change their situation. So when the time the alimony comes up, they start freaking out. However, if you do a tiered system to show them, it's time for you to be self-sufficient, then they know that they got to start finding a job and being self-sufficient. So I don't know what the Tonopah calculator is. Am I going to look at? I would love to see it.
Sue Christensen, Nevada Veterans Association. When you see, a lot of times people don't come back and ask for more custody until child support has been applied. It's not so much that they want the child, they just don't want to have to pay. How do you handle that?
Well, the person still gets their day in court. So it has to be a change in circumstance from when the last custody was ordered. If somebody comes in and says, now I want to have joint physical custody, and you're like, okay, what's the change of circumstance? Well, I have to pay child support. That's not a change in circumstance. That's your duty as a parent per law to take care of your child. You have to show a change of circumstance. So you apply the law. If they don't have a change in circumstance, then custody doesn't change. However, if the parent says, I've been in a position where I couldn't care for my child, and now I have a place, a bedroom for the kid, you just have to look at it individually.
Leslie Caliano, Veterans in Politics. How do your personal values guide your decisions, and what ethical principles are most important to you? And can you also ensure that integrity and fairness is upheld in emotionally charged cases?
First of all, my personal values, again, do not take the bench. Just like my opinion, just like my politics. If your personal values are taking the bench, then you're not an unbiased judge. Ask the rest of the question again, please.
What ethical principles are most important to you, and can you also ensure integrity and fairness in emotionally charged cases?
Yes, I am. All ethical protections are important. I strive to be ethical. That is one of my biggest strengths, is because I am so ethical. I'm the first to tattle on myself. I can't do anything. So ethics is very important. Transparency is very important. Integrity is very important. And I will do what I can in my courtroom to make sure everybody has their day in the courtroom. You can't just hear them. You also have to listen to a person. You have to, there was a study at National Judicial College that said litigants, even if they won, they got what they wanted, if they walked out of that courtroom feeling like they hadn't been heard, they didn't feel like that there was a fair case, that the judge was fair. So it's really important to make sure that the person's voice is not just being heard, but listened to. Okay. Yeah, no, I'm good. My goal is to get through all of your questions.
Gary Jacobs, Armed Forces Chamber. How do you handle self-represented litigants while maintaining neutrality and avoiding the appearance of advocacy?
Self-represented litigants are my favorite litigants. They are. I think the attorneys mess everything up. I think, honestly, the attorneys, it's really sad how people will go bankrupt going through a divorce. It gives me heartburn. I won't give them legal advice, but I can tell them, you need to file a motion to change child support, a motion to change custody. I direct them to the self-help legal, family law self-help center, but also all their pleadings are online. So I've printed them out, and I'm like, here, this is what you need to file. I can't tell you how to fill it out, but I can tell you this is what you need to file. So I started doing that because it kept just the traffic at the Family Law Self-Help Center down. So that is what I do.
Cindy Lake, Veterans in Politics. Your thoughts and feelings on TPOs. Do you issue them? Do you think they're effective? Do you think they're prohibitive in any way? Do they work?
I don't issue TPOs. 2 weeks out of a year, I will issue emergency TPOs because I am on call for those. We have commissioners that issue them. TPOs are a piece of paper. Do they work? Not all the time. Are they needed? Absolutely. It's good to have that record. And
I was just going to ask you a question. What's a TPO?
oh, temporary protective order.
Oh, okay.
Okay. And so it can go from that's okay. It can go, sorry, listeners, temporary protective. And then once the temporary protective order is issued, it can be extended into a protective order. So it drops the temporary and becomes a protective order. And that can be issued for a substantial period of time. The consequences are, if you get one, then the person who is prohibited from contacting the person, well, they can lose their kids. They can lose their Second Amendment rights. There's consequences on that side. However, if you don't issue it, then again, like I said, somebody could die. So you have to approach them very carefully, very slowly, and meticulously. Mm-hmm.
Okay. Sue Christensen, Nevada Veterans Association. Do judges have domestic violence training? And if they don't, would that be something that would be beneficial for them so that they can spot it and be more helpful in that area?
I'm going to confess, I didn't get any training when I took the bench. I hit the ground running. I was lucky that I had training when I was an attorney on domestic violence, because domestic violence affects children. It actually affects children's development with their brain, and even domestic violence when the child is in utero. It affects the chemical makeup. So I have that training, but it's not because from the bench, exactly. Yes, judges need training, absolutely. When you go to National Judicial College, I think there's a class that teaches you on it, but they have so much that they're teaching you. It's just kind of like a fire hose just spraying at you. But I would advocate for training for judges, more training, at least mandatory. Like attorneys have mandatory CLEs that we have to do, certain continuing legal educations. Why not a mandatory 2-hour, 3-hour class or something like that on domestic violence? I would absolutely be down with that.
Okay, Judge, we're going to give you 1 minute to reiterate again why we should vote for you or why we should endorse you for the position that you're going for.
My year on the bench, I have learned that divorce is an illusion. Those litigants may be thinking that they're getting separated. They are separated on a piece of paper, but they are going to be together. They're going to be together at every birthday, at every graduation, at every wedding. And God forbid anything happens to that child, they're going to be together at the hospital crying over that child. I remind these parents of the importance of their children, and I bring humanity back into the courtroom. With your endorsement, I will win this election, and I will keep humanity in the courtroom. Thank you.
Thank you. That concludes this portion of the joint veterans endorsement interviews. Once again, we'd like to thank our sponsors, Judge Mary Perry, Department, Family Division, Department P, and Judge Jacob Reynolds, District Court, Department 29. Thank you very much, Judge Kerri Maxey, and that is it for this afternoon.